Thank you for joining our Debbie's Dream Foundation Curing Stomach Cancer webinar. Today's webinar is on basic estate planning and advanced directives with advocate and attorney Martin Baba. I am Britt Aaron, Programs Director for Debbie's Dream Foundation Curing Stomach Cancer, and I will be moderating today's webinar. We would like to thank our sponsors, Genentech, Lilly Oncology, Merck, and Taiho Oncology for providing funding to make this webinar possible. You will be able to ask questions during this presentation. You can type your questions into the questions section that appears in the webinar menu. We will address questions at the conclusion of the presentation as time allows. In addition, the recording of this webinar will be accessible on our website in the lecture library. First, I will share information about stomach cancer and Debbie's Dream Foundation. Then, we will hear a presentation on basic estate planning and advanced directives with Martin Baba. The presentation will be followed by a question and answer session. In 2018, it was estimated that more than 26,000 Americans would be diagnosed with stomach cancer and more than 11,000 would die. Most patients are diagnosed at stage 4 when the 5-year survival rate is only 5% and the incidence rate in younger populations has increased. Yet many know very little about this deadly disease and little research is being done. Pictured here is the founder of Debbie's Dream Foundation. Debbie was diagnosed with stage 4 stomach cancer in April of 2008. She had no risk factors for stomach cancer and her symptoms were very vague. At the time, she was told that her chance of being alive in 5 years was only 4%. She endured harsh chemo regimens and targeted treatments and experienced many recurrences over 9.5 years. Unfortunately, Debbie passed away on December 23, 2017, at the age of 50. She dedicated herself to helping others with stomach cancer by raising awareness and providing resources and education. Debbie founded DDF in April of 2009. As an organization, we are a member of several advocacy coalitions, including the Deadliest Cancer Coalition, the Patient Equal Access Coalition, the State Patient Equal Access Coalition, and One Voice Against Cancer. Debbie served for many years as a patient advocate on numerous committees and task forces. As an organization, DDF will continue her important work and legacy. Debbie's Dream Foundation is dedicated to advancing funding for stomach cancer research, raising awareness about stomach cancer, and providing education and support internationally to patients, families, and caregivers. Our ultimate goal is to make the cure for stomach cancer a reality. You can learn more by visiting our website at www.debbiesdream.org. In a few short years, DDF has achieved many great milestones. We have 29 chapters across the U.S., as well as chapters in Canada and Germany, and events are ongoing around the country. Our patient resource and education program helps patients, their families, and caregivers around the world by matching them with survivors and caregivers using disease-specific criteria, including age, stage, biomarkers, and location. We host educational webinars and symposia year-round, and our website contains an in-depth information about stomach cancer that can be translated into more than 60 languages. We have also provided $1 million in research grants to date and advocate each year during our Stomach Cancer Capitol Hill Advocacy Day to add stomach cancer to the Department of Defense's peer-reviewed cancer research program. We will be returning to Washington, D.C. next February to maintain funding for researchers. These efforts have resulted in nearly $18 million being awarded to stomach cancer researchers over 3 fiscal years. Please consider joining us February 2020 in Washington. More information can be found on our website under the heading Take Action. This is a current snapshot of our website's homepage with links to numerous resources. Here, you can see some of the many events we have on the horizon, such as the second and third parts of our legal series, which will be hosted on July 23rd and August 6th. On September 6th, we will have another webinar on clinical trials updates. In October, we will have our local brunch-in. In New York, we will have our annual Night of Laughter on October 6th. On October 19th, we will be on the Dana-Farber campus at Harvard for our symposium. On November 2nd, we will be in North Carolina for our 6th annual golf tournament. On November 9th will be our international symposium at the Cleveland Clinic in Weston, Florida. On November 13th, we will be hosting another webinar on nutrition. On November 14th, we will have our local annual Fort Lauderdale golf tournament. And on December 6th, we will have another webinar on precision medicine. CDF is headquartered in Plantation, Florida. Our office hours are Monday through Friday, 8:30 a.m. to 5 p.m. Eastern Time. Also on the slide are important phone numbers and email addresses you can use to contact our office and staff. This information can also be found on our website. We would like to introduce Martin Baba. Martin is an 8-year stomach cancer survivor and DDF advocate. Martin has been practicing law in the state of Ohio for over 27 years. He has attended DDF's Advocacy Day for the past 5 years and hopes to further progress breakthroughs and treatment options for patients who have been afflicted by stomach cancer and their loved ones. As an adult, Martin has had somewhat of an unusual medical history in that he has experienced 2 different kinds of primary cancers. Initially, he was diagnosed and treated for a rare form of non-Hodgkin's lymphoma in 2006, and then diagnosed and treated with stage 3B diffuse gastric adenocarcinoma in 2011. As a lymphoma patient, Martin had a wealth of resources and options available to him, from clinical trials, cutting-edge standard treatment, a vast array of patient resources, and an overall sense that his stage 4 lymphoma diagnosis was treatable. As a gastric cancer patient, he saw that there was a stark difference in terms of patient resources, treatment options, and positive outcomes. Martin is often approached by other cancer patients and survivors and has asked for legal assistance. We thank him for joining us today, and now, Martin, I will turn the webinar over to you.
Thank you, Britt. The initial reaction to having a cancer diagnosis to both a patient and a caregiver, it can be described as including shock and disbelief, particularly with gastric cancer. There's a sense of feeling overwhelmed about fear and worry, stress, anxiety, hopelessness, and sadness. Next slide, please. The things that confront us as patients and also as caregivers are, we need to understand a very difficult and complicated disease. We have to be concerned about choosing a healthcare team, learning about treatment plans and options, learning about clinicians and oncologists, wondering how we'll look and how we'll feel, how we'll respond to treatment, will it work? We now have anxiety about scans, lab results, blood tests, procedures. We worry about finances and work. We worry about our family members and how the process will affect them. Next slide, please. So one of the things that we can do, one small step to kind of address our newfound situation, is to gain control of our future. And one small way that we can do that are through advanced directives. So I'm going to be talking today about 2 things regarding advanced directives. The first is a healthcare power of attorney, and the second is a living will. One of the themes that I'm going to communicate this morning or this afternoon is that communication is the single most important step in healthcare planning. That means communications with family members, that means communications with our clinicians, and that means communicating our wishes through things like advanced directives. The first thing I'm going to point out is that advanced directives are legal documents. They provide detailed instructions about who should oversee your care and your end-of-life wishes if you are unable to speak for yourself. Next slide, please. The 2 things that I would point out that are important are that these are documents that come into effect when a patient is incapacitated. So long as the patient remains capable of directing his or her decisions, these documents do not kick into effect. But there may be a time when a patient lacks the capacity to make those decisions for himself or herself. So for those reasons, we need to have documents that designate a person or persons to help us make those decisions. Communicating to our healthcare proxy or surrogates what our wishes are in advance is critical. The reality is that in many situations, it's very hard to talk about these issues. We're talking about cancer. We're talking about a cancer that's particularly difficult to treat. We're talking about a cancer that has a very oftentimes dire prognosis. So the key here is that we want our wishes to be known and that we want them to be followed. We recognize that if we make these wishes known to our family, that it comforts our family members to know what we want. It saves our family members from having to bring up the subject themselves. It helps us gain a sense of peace of mind and making choices for ourselves instead of leaving that burden to our loved ones. And this is something that that I think most every patient is concerned about. Not only is their own well-being, but how does our disease affect our close loved ones and our family. Next slide, please. So throughout this seminar, I am going to be referring to different terms, things like proxy, designee, agent, and these are all kind of synonyms for the same idea. Now, the brief history with respect to advanced directives is that they're a relatively new legal instrument developed in 1991, so they haven't been around forever. And the key to both of these two documents, the healthcare power of attorney and the living will, is that it's about making your own healthcare decisions. And we do this in the context of hospitals, nursing homes, and HMOs. Next slide, please. So again, we talk about communication, and if talking with your family and other loved ones is too hard, we need to consider having a family meeting, which may include a social worker, perhaps a member of the faith community, or some kind of individual who can help facilitate that discussion. Next slide. So my talk this afternoon is going to mainly focus on the healthcare power of attorney and the living will. But we also need to be aware of DNR orders and things like donor registry enrollment forms. Next slide, please. So the illustration here shows two people, talking about perhaps difficult decisions. And, the things that we don't want to do is make our wishes known when it's too late. These are things that we should think about trying to do when we have the benefit of clarity of mind, of not being under duress or under any kind of pressure, and that we can make these decisions so that, again, we don't burden our family with trying to put them in a position where they have to guess or perhaps even fight over what they believe our wishes might be. Next slide, please. So filling out advanced directives gives people control over their health. Choices about end-of-life care can be hard to make, even when people are healthy. But when people are seriously ill, such decisions can be overwhelming. For instance, some cancer patients might want to try every drug or treatment in the hope that something will be effective. Others may be inclined to stop treatment. Although patients may turn to family and friends for advice, it's ultimately the patient's decision. So in addition to this theme of communication, next slide, I want to stress that these are patient-directed documents. There's not one size fits all. Just as every patient and every caregiver is going to have different perspectives about this disease process, well, these different documents are going to reflect those different wishes. One size does not fit all. So the first document I'm going to talk about is what we call the healthcare power of attorney. It's also referred to as a medical power of attorney. This is a document that allows people to name another person to make decisions about their medical care if they are unable to make these decisions for themselves. We sometimes call it a healthcare proxy, a healthcare power of attorney, or a durable power of attorney. People often appoint someone that they know well and trust to carry out their wishes. This person is what we call the healthcare agent, the surrogate, or the proxy. Next slide, please. So in terms of like the basic considerations about who we choose as our healthcare proxy, a couple bullet points. First of all, it needs to be an adult. Secondly, it needs to be or cannot be your healthcare provider. And then lastly, we just have some basic considerations about proximity and who is best to fulfill that task. Sometimes it might be the primary caregiver. It doesn't necessarily have to be. Sometimes it could be a spouse, but it doesn't, again, necessarily have to be. So, you know, one thing that I think is very important in terms of our specific community, the gastric cancer community, is that our healthcare proxy be someone who is a strong advocate and someone who's able to deal with difficult situations and personalities. One of the most recurring themes that I encounter with fellow patients and survivors is the difficulty that we encounter with getting treatment and pursuing treatment options. So if we're not able to make those decisions ourselves, we need someone who has the skills, the willingness, and the ability to be someone whose voice is heard and who can advocate for us. Now, the duties of a healthcare proxy are in general to make decisions like the patient would make the decision. So the healthcare proxy's duties are not to substitute his or her wishes, but they are to do what the patient believes is what is suitable for the situations. So the duties of a healthcare proxy include receiving the same medical information that the individual would receive, conferring with the medical team, reviewing the medical chart, asking questions and getting explanations, discussing treatment options, requesting consultations and second opinions, consenting to or refusing medical tests, procedures, treatments, and this would include life-sustaining treatments, and then lastly, authorizing a transfer to another physician or institution, including another type of facility. Next slide, please. Tips for healthcare proxies. First off, know your medical team. And what the first point that I would make is that particularly for patients that are at a comprehensive cancer center, there is a lineup or a team that is assigned to the patient. So it's important for the healthcare proxy to make themselves known to these actors or these people. That includes the physician, the physician's assistant, their nurse practitioner, and the nurse. So it's very important for the healthcare proxy to know the players who are involved in the patient's care. The second thing that I think is very important is that the healthcare proxy understand things like the patient portal and how to review a medical chart. One of the things that I know is that whenever I've had to deal with my healthcare providers, whether it's my oncologist or whether it's my primary care physician, patient portals are extremely important tools of communication. My experience has been positive in that, for the most part, every time that I've sent a message through a patient portal in terms of either my care, expressing concerns about my condition, or otherwise communicating with the patient, with the physician's office, my messages have generally been returned within 24 hours. So having access in terms of things like a username and a password to a patient portal are critical, because this is the best way that patients and caregivers can communicate to our oncologist. The next thing that I suggest that is important for a healthcare proxy is that they obtain a basic understanding of the disease process and what the treatment options include. So no one is asking, either a patient or a caregiver to become an expert on stomach cancer, to fully understand all the treatment options, but there needs to be some basic literacy in terms of terminology, in terms of like the basic chemos and staging and things like that. Next slide, please. So the next thing we're going to talk about are what are called living wills. Next slide, please. A living will, unlike a healthcare power of attorney, is a document that's used for people to state whether or not they would like to receive certain types of medical care if they become unable to speak for themselves, and they apply to more limited situations than the healthcare power of attorney. So these would address situations that would include life-sustaining treatment and being in a terminal condition or a permanently unconscious state. So how does that kind of actually come into play? Well, it would address issues about the use of machines to keep people alive. This could mean ventilators, respirators. It could address issues about DNR orders, tube feeding, withholding fluid and liquids, and lastly, organ and tissue donation. Next slide, please. So the first important element of living wills is that it deals with what we call life-sustaining treatment. So these are defined as any kind of healthcare intervention that would include artificially or technology supplied nutrition and hydration. And the examples are listed there. Next slide, please. The next element of when a living will comes into play is when there is what we call a permanently unconscious state or a terminal condition. A permanently unconscious state means that there's an irreversible condition where the patient is unaware of themselves or their surroundings and that is on a permanent basis. The notion of a terminal condition or a terminal illness, on the other hand, is a little bit more vague, and it can address issues about irreversible, incurable, or untreatable conditions caused by the disease, an illness, or an injury. Next slide, please. Again, the most critical thing that patients need to realize or understand is that one size does not fit all. So we could have, as a hypothetical, a question about, well, what would you want to do if there was a less than 5% chance that you would respond to treatment? And people would react differently. I mean, some people might be concerned about the effects of chemotherapy and whether they wanted to endure such things as pain, nausea, neuropathy, things like that. Other people might be more concerned about their quality of life. Other people might be concerned about being a financial burden on their family. And lastly, other people might be concerned about losing their cognitive functions or losing their physical functions. Next slide, please. The important thing to remember is that you, as the patient, have the right to make your own decisions about treatment. Filling out advance directives gives you this ability to be in control. They're a choice. You're not required to fill out advance directives, but again, if we want to try to assert some degree of control over a situation, particularly that can cause us to feel completely out of control, we can do this through expressing our needs and wishes. Next slide, please. The situation may arise that people do not have advance directives, either because they don't have them, because they haven't gotten around to it, or perhaps they have thought about the process and they've consciously made a decision not to fill out these or have these documents prepared. If that situation arises, most states would have a set of laws that would dictate who is the person that is supposed to serve in that capacity. So in most instances, for instance, in the state that I'm from, which is the state of Ohio, the pecking order would be a spouse, adult children, parents, siblings, or the nearest relatives. Next slide, please. So advance directives are important. Obviously, if you have, a recent illness or a serious medical condition, the reason why I feel that they're terribly important is because you don't want situations where you are burdening not only your family, but also your healthcare providers with family squabbles or disputes about what to do about the patient. So having been in a hospital setting on numerous occasions, I can tell you one of the things that I have heard anecdotally from healthcare providers in terms of physicians and particularly nurses, as that the one thing that is a terrible burden to the healthcare providers are squabbling families over what to do regarding a loved one. And, we need our healthcare providers to focus on patient care and treatment, and they're not equipped, and their time shouldn't be burdened by dealing with family drama, if you will, regarding what to do. Next slide, please. Now, if you've chosen to complete advanced directives, the question is, well, what do you do with them? Well, the first thing is, again, we review them with our family, and then the next thing that I would suggest is that we make them part of our medical records. So reviewing them with your healthcare provider, which could include your primary care physician, and also making sure that as part of our medical record, our advanced directives are part of that record. One of the tools that I encourage my clients to utilize are cloud-based sharing devices such as a Dropbox or Google Drive. These are places where electronic copies of these documents can be placed online on the cloud, and you can invite different people to join that document or that folder, and we know where those documents are. Next slide, please. So before we go on to the next topic of basic estate planning, the one thing that particularly I find is a little bit troublesome with healthcare providers is that they will correctly ask patients, especially upon admission, whether they have advanced directives. The concern that I have is that in my experience, I've noticed that physicians or healthcare entities have kind of pushed these documents in front of patients like they might a HIPAA release or signing some sort of general release for insurance. These are documents that shouldn't be just simply handed to someone and sign here, sign here. These are documents that do require some degree of deliberation, some careful consideration, and they shouldn't be signed kind of as an afterthought or in a hurried manner. Next slide, please. So the next thing we're going to talk about are just basic concepts about estate planning and probate. Next slide, please. So probate is a term that refers to a legal proceeding where we administer certain types of property that are called probate property or probate estates. So a probate proceeding involves doing things that are related to paying the claims or the debts, the expenses and the taxes of a person who has passed away. We call that person the decedent. And then we are concerned about distributing the assets of the decedent or the estate under the person's will. There are two terms that come into play with probate. Next slide, please. In terms of actors, one would be what we call the executor. That is a person who is a fiduciary or basically someone who's designated under a will to administer someone's estate. And then if someone does not have a will, we call that person an administrator. So this would be someone who is not designated by a decedent, but who is appointed by the court based upon their relationship to the decedent. Probate property does not include all types of property that a decedent may have owned. What probate property consists of is property that's titled in the decedent's name and is not transferable on death. Next slide, please. So there are certain types of property that are not included in probate. And these are types of assets or types of things that people can own that they need to be aware of, that there may be a need to designate either one or multiple beneficiaries that distribute the property upon death. So in some instances, property can be held as what are called joint tenants with right of survivorship. Each state is going to have different laws regarding what types of property can be held as a joint tenant, but the basic idea is that let's use the example of real estate. So people can own in some states real estate with a joint tenancy with a right of survivorship. So the best example would be that you would have a spouse or two spouses, a husband and a wife, that own a marital residence with both of their names on the deed, and there would be specific language that says that there's a right of survivorship. So in that instance, the other one half of the house that belonged to the decedent would pass to the surviving spouse by virtue of the deed, and it wouldn't have to pass through probate. The next thing that we can do is we can designate some financial accounts. The best example would be like a checking account or a savings account, and have what are called POD, or payable on death provisions, or TOD, transfer on death provisions, to name the beneficiary. These also apply to things like life insurance policies and retirement benefits, such as an IRA. So with non-probate property, these assets pass directly to the named beneficiary, the survivor or the successor in interest, without the use of the will. The important thing here is that if we are newly diagnosed, it is a good time to review all these documents. So the short list that newly diagnosed patients should think about are having a review, particularly with an attorney, regarding their deed, their car titles, titles to any other vehicles, boats, campers, trailers, how their bank accounts are held, checking accounts, savings accounts, brokerage accounts, and then consulting things like life insurance policies that may exist through work or outside of work, and retirement accounts such as an IRA, a Roth IRA, and a 401k account. Next slide, please. So what is a will? Well, a will is a written instrument. It's a document that sets forth how a person would like to have his or her probate property distributed upon death. To be valid, a will must meet certain legal requirements. Next slide, please. So with a will, a person needs to be an adult. They need to be at least age 18 and have reached the age of majority. In most cases, a will needs to be a written instrument. It needs to be signed. It needs to be notarized or witnessed. And the reason why we do that is because we want to make sure that the maker, or the person who made the will, is of sound mind and sound body, and they've done so with a clear mind. They're competent to do so. Next slide, please. What are the benefits of having a will? Well, the most important thing is that it makes the entire process of distributing a decedent's estate more efficient. That translates into saving money. It can reduce taxes. It can reduce the transactional expenses of administering a decedent's estate. And one of the other important things is that it can eliminate the need of the posting of a bond, which might otherwise be required if a person passes without a will. One of the things that I encounter quite frequently is what happens if I don't have a will. Well, if you don't have a will, the wrong answer is that the property is going to go to my state. So a person who does not have a will is not going to lose their property to the state of Ohio or the state of Florida or the state of Texas. There's going to be a statute that sets forth who should inherit property in terms of that person's next of kin. Next slide, please. Part of estate planning may include the use of trusts. Now, trusts are very complicated, in some instances, instruments, and it's certainly well beyond the time allotted for me to talk about different types of trusts. But the general idea of a trust is that instead of giving property directly to one person, we give it to a trust or an entity that holds it for the benefit of someone else. So a trust exists when one person, which we call the grantor, gives property to someone who's called the trustee to hold or manage assets for the benefit of one or more persons. Quite often in estate planning, we use instruments that are called revocable trusts. Sometimes they're referred to as living trusts. And it's something where the grantor, which may be the patient, has the ability to change or modify or revoke these documents during his or her lifetime. Next slide, please. What's in a trust? Well, a trust can be funded by anything that the settlor or the grantor wants it to include. These could include checking accounts, financial accounts, stocks and bonds, a home and real estate. Sometimes trusts are funded initially, sometimes they're funded upon death. The use of trusts is important in certain situations where the grantor or the settlor may not feel comfortable giving the property directly to designated beneficiaries. So the most common instance might be where the grantor has young children or young adults and they are concerned about mismanagement. The next situation might be if there is an adult child with special needs, or there may be a surviving spouse that lacks the ability or the desire to manage their own finances. So trusts are ways where a settlor can increase the likelihood that funds are not mismanaged upon death. Every attorney that works in this area has heard horror stories about people inheriting money from spouses or from other loved ones, and within a matter of days or weeks or months, the money has been spent, blown, and their nest egg or their safeguard has been wasted away. So that concludes my presentation today. Again, the themes that I touched on today are that the patient has the control, one size does not fit all, and as with everything regarding our healthcare, communication is the key. Thank you.
Thank you so much, Martin, for sharing with us today and sharing your expertise. We did receive some questions during your presentation, so I'd like to ask you a few questions in our remaining time. The first question that I received was, what do I do about having someone who handles finances, such as paying bills?
So the document that we would use to help someone pay bills is what we call a durable power of attorney. The reason why it's called durable is because if we have a general power of attorney, it's going to stop being effective if the person or the patient becomes incapacitated. The durable power of attorney, on the other hand, will survive that event. Now, the durable power of attorney is something that would basically give the proxy, instead of being the healthcare proxy, they're going to basically be the financial proxy to do things like write checks, make deposits, sell property, purchase property, and otherwise handle the financial affairs of the patient. This is extremely important about how we choose our attorney in fact. So we want someone just like with our healthcare proxy that's going to be financially responsible, financially literate, and capable of handling our finances. One thing that I advise people to be careful about is awarding someone a durable power of attorney immediately. One tool that we use is what we call a springing power of attorney. So what a springing power of attorney is that it kicks in when our patient or our individual becomes incapacitated. So what happens there is that our power of attorney or our proxy has the authority to make financial decisions, but it only comes into play, or it only kicks in upon a written letter or documentation from a physician or healthcare provider indicating that our patient is incapacitated.
And that leads me to the next question, actually, is what do I do if my primary healthcare agent is unavailable or no longer able to serve in that capacity?
Well, this could trigger two things. One would be that we review our advanced directives and our planning documents to see if there is a reason to redo them. As with any significant life event, it could be a divorce, could be a marriage, remarriage, a death in the family. These are all instances where we need to kind of review our important legal documents. So one instance might be that we might need to change who our proxy or who our surrogate is. The other thing that we can do is that we can try to nominate a first or a second alternate as our healthcare proxies. So when I advise my clients, I try to get them to nominate a primary designee, but then we nominate a first alternate or a second alternate if the primary person is unavailable, no longer willing, or otherwise not able to serve in that capacity.
Excellent. We have two more questions. The first one is, what happens if I change my mind about my preferences?
Well, if we change our mind about any of these documents, we're at since they are documents that we have created, we have the ability to revoke them. So if that were to take place, I think it's important for the patient to notify the people that have been previously notified of those changes. I think it makes good practice to kind of formally destroy or document those prior documents. Really, the best practice probably is to replace older documents with newer ones so that we know that the documents that we're no longer happy with or comfortable with have not simply been lost or misplaced or stolen, but they've been superseded by some newer document or instrument.
Wonderful. And the last question is, do I need to hire an attorney?
That's a question that I'm asked a lot. And my answer is that it's probably better practice to hire an attorney to review these documents, because I think what the benefit of an attorney is that they will work with the patient to make a document that fits their particular needs and resources. It's a tailored or it's a curated type of instrument or product that will be created. On the other hand, I think that most hospitals and most every comprehensive cancer center that I have viewed has these types of instruments available. So these instruments are things that can be found on most cancer hospital websites. Other good resources to consult would be a local city or state bar association, a probate court. These are all places where these documents are available. The concern that I have is that the documents are things that require the maker to fill out on their own, and one needs to be very careful about what they put in, and knowing that they have the right to make a document that fits their needs and doesn't have to satisfy some other person's wishes or needs.
Great. So it sounds like it's at the discretion of the patient, really, at the end of the day.
That's correct.
Wonderful. Well, thank you so much, Martin, for joining us today and sharing your expertise with us. Our webinar was brought to you today by Debbie's Dream Foundation, and the recorded version of this and past webinars can also be found in our lecture library on our website. The link is below. We'd like to thank our sponsors again, Genentech, Lilly Oncology, Merck, and Taiho Oncology for providing funding to make this webinar possible. As a reminder, there is a second and third part of our legal series with Martin, so we hope that you can join us again. Thank you again to all of our listeners today. This concludes today's presentation. Please be on the lookout for information about our upcoming webinars for this year. To view any of our recorded webinars as stated previously, please visit our lecture library and search by topic, the topic that you're interested in. We would also love to hear your feedback. There is a survey at the end of the webinar, so please make sure that you take the survey and that we will gather that information. For any questions or suggested topics for future webinars, you can also send your comments to programs@debbiesdream.org. And for more information, you can visit www.debbiesdream.org. This concludes today's presentation. Thank you so much for tuning in.